Good morning to you again. I am Randy Thompson. I'm one of the board certified civil trial specialists at Kerrigan Estes, Rankin, McLeod, and Thompson. We are a personal injury law firm. It's only the five of us. We don't have any associates. So if one of us says we are going to help you, it's going to be one of us that's going to help you. I'm kind of proud of that fact. We are not a warehouse just trying to run a number of cases through where we never meet our clients. That's not what we do. That's not what this firm was built on. And when I say we are board certified trial specialists, I'm kind of proud of that too, because I think about only 2% of the attorneys in the state of Florida are board certified. You have to take extra tests. Judges have to comment on your abilities and your qualifications. And so I'm kind of proud of that too. But again, I'm Randy Thompson. I am the bottom of the barrel. I'm the last name in the law firm. And this morning I'm going to talk to you a little bit about what is your automobile accident case worth in the state of Florida. How do you know what the value of your personal injury automobile case is worth if it happens to you in the state of Florida? And the answer is, ultimately, if your case can't get resolved through settlement or negotiation, then 6 people on a jury are going to tell you what the value of your claim is. And whether you agree with them or don't agree with them, they're going to tell the defense, the people that caused the accident, and they're going to tell you and your lawyer what they think the value of the claim is. And generally speaking, those 6 jurors, their opinion about the value and the merits of the claim are not overturned on appeal. Appeals happen. Oftentimes because judges give jury instructions that the appellate court says was wrong, or one of the attorneys, either for the plaintiff or the defendant, says something or offers a piece of evidence that was incorrect. And so appeals happen and jury verdicts get overturned and reversed, and you come back and try the case again. But generally speaking, if 6 people on a jury say that the value of your claim is $100,000, no appellate court is going to overturn it just on that fact alone. Now, the vast majority of cases, these car accident cases, never get to a jury. I think probably 85% of car accident cases get resolved short of a jury trial. But in order to understand what the fair value of your claim is, you have to be able to understand what a jury is likely to do with the information they're given in a case like yours. And so that's another reason why you would like to select a board certified civil trial attorney, an attorney who only focuses on civil trials and trying to get people fair compensation for injuries caused by someone else. And that's, of course, what our firm does here at Kerrigan Estes, Rankin, McLeod, and Thompson. So ultimately, the value of your claim is decided by 6 people on a jury if it can't get settled. Well, how does a jury decide what the fair value of your claim is? They're read instructions by the judge who's trying the case. And so once all of the evidence has come in, the judge will read the jury instructions about how they're to come about their decisions. And then the judge will give them, at the very end, a verdict form. And we're going to put it up on the screen for you. This is a Florida standard jury verdict form. It's a 2-page form. There's 7 questions on it. And I'm just going to go through them because it'll give you an idea of what 6 people on a jury would do if your car accident case got in front of them. So the first question that the jury is asked to answer is number 1. Was there negligence on the part of defendant Rachel Rowe, which was a legal cause of damage to plaintiff John Doe? So in this example, the person that caused the accident is Rachel Rowe. She's the defendant. And the person that is injured, the person that got hurt in the accident, allegedly, is John Doe. And so the very first question the jury is asked is, well, did the defendant do anything wrong? And so let's say that the jury decides, yes, they did, that Rachel Rowe was negligent, and her negligence was a legal cause of the damage. So they check yes to that. And then the very next question they're asked is, well, did John Doe do anything wrong? So question number 2, was there any negligence on the part of the plaintiff, John Doe, which was a legal cause of his damage? Well, so if John Doe was sitting still at a red light, minding his own business, and his brake lights worked, and he got plowed into from the driver behind, no, there was no negligence on part of John Doe, you would think the jury would conclude. But let's say that there's evidence that the plaintiff, John Doe, might have been speeding. He might have been going 10 miles an hour faster than the speed limit. So a jury could decide, well, okay, well, the plaintiff, John Doe, was partly at fault in this accident. So let's say that they check yes to number 2. And then we get to the third question, which is, tell us what is the percentage of fault that you place on Ms. Rowe and on Mr. Doe. And those percentages can be whatever the jury decides them to be. They can be 90% on Rachel Rowe and 10% on John Doe, 95% to 5%, as long as they total up to 100%, whatever those numbers are, they can be 50-50, 70-30, 30-70, whatever those numbers are, the jury can write those in there. And again, no appellate court is going to overturn that. So let's say that the jury decides that it's 70% Rachel Rowe's fault and 30% John Doe's fault. Then the judge gets to the next question, which is damages. How has the plaintiff, Mr. Doe, been injured? And so question number 4 is, what is the total amount of John Doe's damages for medical expenses incurred in the past and medical expenses to be incurred in the future? Now, a lot of instructions will go along with these individual questions. The judge will read instructions, but in order for the jury to have numbers to put in that box, it has to come from expert testimony. It has to come from the doctors who say, I believe within a reasonable degree of medical probability that Mr. Doe will have to have these procedures in the future because of this car accident, and testimony about what his past medical expenses were. And then question number 5, what is the total amount of John Doe's damages for lost earnings in the past and loss of earning capacity in the future? So if his injuries caused him not to be able to work, and he can show that evidence and produce that evidence, a jury will consider that, and they will decide whether to award damages for that and whether the car accident caused that. And as far as future earning capacity, let's say the doctors say, well, you're going to have a surgery. Well, so we know you're going to be out of work. So we can project future lost earnings. And so those numbers go in there. And then question number 6 in Florida is important because it goes to intangible damages. Question number 6 says, did John Doe sustain a permanent injury? I could spend several shows talking to you about permanent injuries, but in this section, what I will simply say is a doctor has to say that as a result of this car accident, the client has either sustained a permanent injury or a permanent aggravation to a pre-existing injury. If the answer to that question is yes, did John Doe sustain a permanent injury, then the jury goes on to answer question number 7, which is what we call the intangible damages. How your life has been changed and altered and devastated in certain circumstances because of the fault of somebody else. And then the jury goes and they add all of those numbers up. They add all of the blanks up and they come to a bottom line number. But then the judge, in looking at the comparative negligence, reduces the amount of damages that John Doe would recover, in this case, by 30%, because the jury decided that he was 30% at fault. So he only gets 70% of his medical expenses. He only gets 70% of his lost wages. He only gets 70% of his intangible damages, the damages that the insurance companies make such light of by saying pain and suffering. But until you've woken up every morning and your back still hurts, or your leg is still on fire, or you still have a stiff neck years after an accident, and you never had it before the accident, you understand how significant these types of injuries can be and how they play out as we age and as we go through our life. Typically, as we get older, we don't get healthier. We need health care more. And we need to see doctors more, and more things hurt us. So to have an attorney who specializes in civil trial cases, who knows and understands the jury instructions, how they work, when they work, which ones apply, which ones don't apply, and know the information that 6 people on a jury have to hear in order to help you receive adequate compensation in your case. So that's a brief overview of what jurors try to do when they are looking at cases, and what I, as a board certified trial lawyer, tell the adjusters the jurors are going to do and how they're going to respond. So again, I'm Randy Thompson. I'm one of the attorneys at Kerrigan, Estes, Rankin, McLeod, and Thompson. Our phone number is 850 and then all fours 444-4444. You can reach me at randy.thompson@kerrigan.com. And I would encourage you to check out our website, kerrigan.com. We've got a lot of information about the attorneys, about the types of cases that we handle. And we're glad to talk to you. We represent you on a contingent fee basis, which means it doesn't cost you any money to talk to us about your case. Feel free to call us.